Hello, welcome back to English Law. So I'm carrying on looking at psychiatric harm, and now I'm going to consider a really important case to do with that, because people have been much more cognizant of psychiatric illnesses in the 20th century and into the current century. So previously courts were very loath to grant damages due to psychiatric injuries only due to physical injuries. But over time, that has changed. So we've undergone an evolution, becoming more cognizant of mental health, perhaps overly aware of it. So here is a very important example. White against Chief Constable of South Yorkshire Police, 1999, which is an appellate court decision. So you might know that England is divided into 48 counties, and those are subdivided, but the police have got various districts. Yorkshire, being the largest county in England, is subdivided to North, South and East Yorkshire. So South Yorkshire's based around Sheffield. So the head of the police in each area is called the Chief Constable. So the Chief Constable was being sued not personally, but his office, as in if the Chief Constable was found liable, then he wouldn't have to pay out of his own pocket. It would be out of police funds. Anyway, so Lord Steyne here lay down the policy reasons why different rules have been created for the recovery of two different types of damage. And this is what he had to say. There is no doubt that the public draws a distinction between the neurotic and the cripple, between the man who loses concentration and loses his leg. It's widely felt that being frightened is less than being struck, and trauma to the mind is less than lesion to the body. Many people would consequently say that the duty to avoid injuring strangers is greater than the duty not to upset them. The laws reflected this distinction as what I would expect, not only by refusing damages for grief altogether, but by granting recovery only for physical harm, only psychical harm late and grudgingly, and then only in very clear cases. In tort, clear means close to the victim, close to the accident, close to the defendant. Firstly, there is a complexity of drawing the line between acute grief and psychiatric harm. The symptoms may be the same, but there is a greater diagnostic uncertainty in psychiatric injury cases than in physical injury. The classification of emotional injury is often controversial. In order to establish psychiatric harm, expert advice is required. This involves the calling of consultant psychiatrists on both sides. It is a costly and time-consuming exercise. If claims of psychiatric harm were to be treated generally as on a par with physical injury, it would have implications for the administration of justice. Secondly, there is the effect of the expansion of availability for compensation on potential claimants who have witnessed gruesome events. I do not have in mind fraudulent or bogus claims. In general, it ought to be possible for the administration of justice to expose such claims, but I do have in mind the unconscious effect of the prospect of compensation on potential claimants. The third factor is important. The abolition or relaxation of the special rules governing the recovery of damages for psychiatric harm would greatly increase the class of persons who can recover damages in tort. Fourthly, the imposition of liability for pure psychiatric harm in a wide range of situations might result in a burden of liability on defendants, which may be disproportionate to the tortious conduct involving perhaps momentary lapses of concentration, e.g. In a motor car accident. Close quotation. So a number of ellipses I left in there. So if people knew that they could get pecuniary compensation for psychical harm, then a lot of people, consciously or unconsciously, would say they had suffered this when they hadn't really. And what is psychiatric harm as opposed to ordinary sorrow? People being in mourning over maudlin events, the death of a romantic partner or a relative or a dear friend. Or what if it's not such a close friend, and how close is close enough to recover damages here, and how severe does the psychical harm have to be? And it would make us a nation of snowflakes, which many argue is happening already, to really be histrionic and go overboard about any reverse, any setback, any minor physical injury, and make us a bit too precious, turn us all into crybabies. So much money would have to be paid out by public authorities, who then have to be overly circumspect, not allowing all sorts of useful and enjoyable activities for fear that someone would come to harm. So much money, public money paid out, therefore the police would have less money to be spending on policing, trying to keep us safe, which would therefore lead to more physical harm, more psychiatric harm. So it would actually backfire hugely. So let's examine some of the control devices. Proximity is the modern word which has been substituted for Lord Atkin's use of the notion of neighbour. That was descriptive of a relationship, a close relationship with the defendant and claimant, not necessarily emotionally close. there has to be the requisite degree of proximity, such that the defendant therefore owes the claimant in focus. And the quotation from Donahue is, directing his mind to the acts of omissions which are called into question. So these labels are there to show that there's some sort of duty, some special relationship, or a voluntary assumption of responsibility. What's tried by all these cases is the application of proximity works to make this possibly illimited group of putative claimants very select indeed, and therefore we can determine who they actually are. Because if there's indeterminacy, well, then the whole population could claim. So I'm going to look at proximity and components of the duty test, and I'm going to look at some case law pertaining to claims about nervous shock, pure economic loss, and these will show really didactic examples of the applicability of these components. I'm going to think about the devices that the courts have found to restrict claims of psychiatric injury. Parliament, curiously perhaps, has not passed legislation about this. The Law Commission in 1998 suggested some legislative remedies, but they have not been adopted by Parliament. So there have to be recognisable psychiatric injuries arising from shock. So emotional and psychological harm is recognised by the psychiatric profession. There's post-traumatic stress disorder, PTSD, which is really only recognised after the First World War. A lot of shell-shocked people who'd been valiantly going into action, fighting many battles, would eventually crack and then be a gibbering wreck, crawl into a ball on the floor or whatever, or desert, completely out of character, and sometimes were executed by a firing squad for it, because we didn't realise what PTSD is. They can have flashbacks years later. Sometimes they were in the army and the police, and they would do terrible things because they'd been haunted by these horrific scenes they'd witnessed. So organic depression and pathological grief disorder can be remedied with money. There's obviously psychiatric treatment, but we're talking about the juridical remedy. Now these can be remedied so long as the traumatic or shocking events is what caused them. That's in law, it's nervous shock. Lord Ackner in Alcock against Chief Constable South Yorkshire 1992 said, shock involves a sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. Close quotation. Agitate in the French sense of like to shake, obviously not physically shake, but would really derange the balance of the mind, for the worse. So cause this person to experience deep sadness or abnormality, fury, just be unable to cope. So it must be clear that there's some recognisable psychiatric illness. Lord Atkin said that the law, as it is, there can be no recovery for a psychiatric illness caused by accumulation over a period of time of more gradual assaults on the nervous system. Close quotation. So if it's incremental, several minor things, no, that's not. It has to be one horrendous thing. But subsequent cases appear to have counteracted his ruling. So in what situations can the psychiatric injury be caused? The reason for having this is to find a difference between primary and secondary victims. So there are more and more claims that don't fit into these narrowly prescribed categories. So primary victims are those who've suffered as a physical injury, which then leads to a psychiatric injury. So that's those who were there at the time the hazardous event occurred. They experienced trauma, so a physical injury which led to some psychiatric disorder. So they're primary victims. So it's foreseeable that if they cause some physical injury, psychiatric injury may result. The psychiatric injury doesn't have to be entirely foreseeable. In Page and Smith, 1996, a claimant was driving sensibly, but then a defendant turned to his path. There was a small-scale accident. There was some damage to the vehicles, but the claimant and the occupants of the other car weren't physically harmed in this crash. But before the accident, the plaintiff had suffered chronic fatigue syndrome, known as ME, for 20 years. There's some people think it doesn't even exist, call it the yuppie flu. So after the accident, the claimant was in remission for this condition and was thinking that he'd be able to go back to his pedagogical profession. And he didn't sustain any physical injury, but he said that the accident had caused his illness to return. And then that became prominent and would just never go, permanent and would just never go away. So he could not return to work after all. The House of Lords said there's no justification for saying that physical injury and psychiatric injury are different kinds of injury. Once they have found that the defendant is under a duty of care to avoid occasioning personal injury to the claimant, it's a matter of complete indifference whether it's physical, psychiatric, or the two together. So the application of this principle means, although he hasn't sustained any physical damage, the claimant was permitted to be awarded damages for a psychiatric injury. This is what Lord Lloyd said for a majority of the bench in the House of Lords. The test in every case ought to be whether the defendant can reasonably foresee that his conduct will expose the plaintiff to the risk of personal injury. If so, then he comes under a duty of care to the plaintiff. If a working definition of personal injury is needed, it can be found in Section 38.1 of the Limitation Act 1980. Personal injuries include any disease or impairment of a person's physical or mental condition. But more restrictively, physical injury or fear of the same is necessary as well as being a sufficient condition if there's going to be liability. And that's as in White against Chief Constable of South Yorkshire Police. So if physical injury, the fear of it must be there, right? Okay. So that's enough for the moment. By the way, and plaintiff, of course, we now call claimant. Toodaloo.